This story is from the state of New Mexico and deals with the question of marital privilege. As many of you may know, there have been classic privileges recognized at law. Some of these have included priest-penitent privilege, lawyer-client privilege, doctor-patient privilege, and marital privilege. In each of these contexts, there is a thing where you can say something to a party and that cannot be forced to be revealed at court. Well, the Supreme Court of New Mexico has decided that marital privilege is no longer a thing that exists. So we're going to read their decision and try to understand why they said so and go from there. So let us get started on that. Spousal communication privilege. Rule 11505 of the New Mexico Revised Statutes says that New Mexico spousal communication privilege provides that a person has a privilege to refuse to disclose or to prevent another from disclosing a confidential communication by the person to that person's spouse while they were married. This privilege prohibits one spouse from testifying as to conversations or communications with the other spouse made in confidence during the marriage. The privilege protects confidential communications at the time they are made and may therefore be invoked after the termination of the marital relationship. This court's constitutional authority to recognize or limit evidentiary privilege derives from the power of superintending control set forth in Article 3, Section 1 and Article 6, Section 3 of the New Mexico Constitution. This court determines whether and to what extent an evidentiary privilege should be permitted to interfere with the orderly and effective administration of justice. For this reason, the existence of the statute has little bearing upon whether or not New Mexico courts should continue to recognize the spousal communication privilege. So the Supreme Court of New Mexico just said, yeah, that the fact there's a statute on this is completely irrelevant because we have the power alone to determine whether or not privileges exist. So that's a thing that just happened. This question is one bearing upon practice and procedure, and therefore is one over which the court has ultimate authority. So that pesky statute is meaningless. Quoting, if a privilege is not recognized or required by the New Mexico Constitution or court rule, then the legislature may not enact such a privilege because to do so would conflict with the rules. Our constitutional power of superintending control over all inferior courts carries with it inherent power to regulate all pleading, practice, and procedure affecting the judicial branch of government. Whether our courts should continue to recognize any privilege requires a balance of competing concerns of the broadest kinds. Now, that sounds suspiciously to me like a policy-based issue for which a legislature might be concerned, but apparently not. Only the court gets to determine this. So, again, this statute is completely irrelevant. The administration of justice is coextensive with the pursuit of truth, and but for certain well-defined exceptions, all persons can be compelled to appear in court and give testimony to accomplish this ends. Limitations on this fundamental rule shall be recognized only in very limited extent that permit a refusal to testify or exclude relevant evidence promotes a public good that transcends the normally predominant principle of utilizing all rational means for ascertaining truth. Similarly, the purpose of the rules of evidence is to ascertain the truth by determining what evidence is admissible during trial. Consistent with this purpose, all persons generally are required to disclose any information they may possess that is required and relevant to a case pending before a court of justice. Evidentiary privileges are not lightly created nor expansively construed because they are in derogation of the search of truth. We thus consider whether spousal communication privilege promotes sufficiently important interest to outweigh the need for probative evidence. In doing so, we examine both the justifications advanced in support of the privilege and criticisms of it. And before we do that, one final comment is necessary. Secondary literature discussing spousal privilege abounds. The literature illuminates much. The earliest iterations of spousal privilege can be traced back to feudal England. The privilege took different forms at different points in history, evolved over time, and has not been discussed uniformly. So yeah, as one would expect, this privilege is not a thing that New Mexico or the United States invented. This is something that existed at English common law. It's existed for, half a millennia, but that's not important. New Mexico can just abolish it because reasons. The existence of abundant secondary literature is no justification for us to write yet another treatise on the subject of the history and development of the spousal privilege we have today. Our focus is specific. Our task is discrete. We are here concerned with spousal communication privilege as it exists in New Mexico and to the merits of the policy justifications offered in support of the privilege as a measure upon the ground for which we stand. While it's necessary to consider some aspects of history of spousal privilege to understand the purpose of the privilege we have today, we discuss that history only to limited extent necessary. Readers interested in legal history as an end in itself may explore, as we have, the many secondary sources cited throughout discussions that have followed. So again, even though for hundreds of years people have discussed this and said it's important, we, the New Mexico Supreme Court, know better. So that's just super wonderful. More than 180 years ago, the United States Supreme Court described its policy concerns giving rise to spousal communication privilege in the following manner. The rule is founded upon the deepest and soundest principles of our nature, principles which have grown out of domestic relations that constitute the basis for a civil society, and which are essential to those enjoyed of the confidence which should subsist between those who are connected by the nearest and dearest relationships of our life. To break down or impair the great principles which protect the sanctity of our husband and wife would be to destroy the base solace of human existence. The principles articulated in this case developed into what most commentators characterize as the traditional justification for privilege. It is needed to encourage marital confidences, which confidences in turn promote harmony between husband and wife. The traditional justification for privilege is considered to be an instrument or utilitarian-based rationale because it views privilege as a way to promote the public good by protecting the marital relationship. In addition to traditional justification, a variety of humanistic and privacy arguments have been offered in support of the privilege. Unlike traditional justification, which views the privilege as a means of promoting the public good, the privacy and humanistic theories focus on the value of protecting individual rights. One such justification offered for spousal communication privilege is that it eliminates the natural repugnance that would necessarily flow from forcing a person to testify against their spouse. Pitting spouse against spouse is deeply offensive to widely shared values. Leading treatises summarize that this is a matter of emotion and sentiment, and has in fact been the prime influence in creating and maintaining the spousal communication privilege. The protection of informational privacy and avoidance of unwarranted governmental intrusion is offered as an alternative justification for the privilege. This rationale recognizes that it is morally repugnant to require the disclosure of certain private information or to force an otherwise honest and decent person to choose among betraying his spouse, lying, or going to jail. One federal court quite persuasively made the case for privacy justification of the privilege. Over at least half the past decade, the circle of privacy surrounding each of us has drawn smaller, with each new governmental intrusion and each new technological advance. Courts have sought to preserve, inviolable, some small island of privacy as a refuge for the human spirit, where government may not intrude. Here the question is whether one such sanctuary, protected by common law for centuries, shall be breached, rendering secrets told to wives by husbands fair game for governmental investigation. Sounds pretty persuasive to me, but the New Mexico Supreme Court doesn't care. The United States Supreme Court has recognized that married people have a constitutional right to privacy in their intimate relationships. See, for example, Griswold v. Connecticut, concluding the right to privacy in marital relationships is older than the Bill of Rights. Thus, commentators have relied on this right of privacy to conclude that the abolition of spousal privilege would defend the spirit of constitutional guarantees. Finally, a humanistic theory based on personal autonomy has been utilized to evaluate privileges generally. Under this line of thought, personal autonomy is accepted as the ultimate value in a democratic society. Whether this line of thought has figured into or has any value as to the debate of the benefits of the spousal communication privilege is an open question. When scrutinized, the traditional justification for spousal communication privilege is not as forceful as it may initially seem. One of the principal weaknesses is that it rests on two untested assumptions: that married people know the privilege exists and that they rely on it when deciding how much information to share. Critics argue that there's no empirical evidence to support these assumptions. As to the first of these assumptions, it is likely that most people are not entirely aware of the privilege. The United States Supreme Court, agreeing with this assessment, omitted the spousal communication privilege from the court's proposed rules of evidence. Even if married people are aware of spousal communication privilege, it is unclear whether the availability of the privilege has any effect on the extent to which spouses communicate. The point, expanded in greater detail in succeeding paragraphs, significantly undermines the second assumption underlying the traditional justification. In a relationship involving a layperson and a professional, the absence of a privilege protecting confidentiality could chill beneficial communication because the layperson might refuse to communicate with the professional. And in a professional communication that depends highly on the confidentiality, there is evidentiary wash. While evidence might be excluded at trial pursuant to the privilege objection, but for the privilege, the evidence would not have come into existence. The loss of the evidence admittedly caused by attorney-client privilege is justified in part by the fact that without the privilege, the client may not have made such a communication in the first place. Unlike communication between a professional and a layperson, communication between spouses does not depend on a legal guarantee of confidentiality and does not come into existence because of the guarantee. Last I checked, marriage itself was considered a legal arrangement. It's considered essentially a contract, if you like, but it is a legal arrangement. And so, people are strangers until they get married. So, the idea that they're getting married for benefits, including privilege, doesn't strike me as inherently odd. So I don't know what the Supreme Court of New Mexico is talking about here, but okay, let's carry on. Spouses communicate openly with one another due to trust they place in the loyalty and discretion of each other, not because privilege shields their communications from future disclosure to a court. Additionally, most people are unlikely to alter their behavior based on the privilege because most people seldomly appear in court and do not tailor their conversations about what might or might not be privileged. Because neither assumption underlying traditional justification survives scrutiny, the traditional justification for the privilege seems entirely unfounded. As with traditional justifications, questions have been raised as to whether the privacy and humanistic rationales are sufficient to justify recognition of the spousal communication privilege. For example, Wakemore argued that the natural repugnance that people feel about compelling one spouse to testify against another is nothing more than sentiment. Ooh. And sentimental feelings do not justify interference with courts' truth-seeking functions. Yeah, the fact that, you might feel bad against testifying against your spouse, that's just sentiment. And so, that doesn't really count, apparently. Okay? To the extent that protecting marital privilege is a legitimate goal of rule of evidence, the spousal communication privilege has been criticized as inadequate and under-inclusive. As the privilege has been construed to protect only those interactions through which one spouse intends to convey a message to another, the privilege does not apply to some of the most personal and intimate interactions between spouses. For instance, the privilege would not permit a spouse to decline to testify as to whether or not his spouse uttered inculpatory remarks in their sleep or if they exhibit other irrepressible behaviors like nervousness, tiredness, or illness. This is significant as it's precisely at these private moments when the social mask is removed and a spouse engages in unguarded, unfiltered behavior. Well, for whatever it's worth, other types of privileges don't normally extend to behavior. This point highlights the obvious fact that marriage is a very different endeavor and involves communication quite distinct from whatever relationships occur between laypersons and professionals like doctors and lawyers. Married couples necessarily engage in nearly unlimited range of possible communication acts, and spousal privilege might never reach. Communication between laypersons and professionals, on the other hand, are essential and almost exclusively verbal in nature, unlike marriage. I don't know what to say to that. So while the efficacy of privileges protecting the communication between laypersons and professional seems quite sensible and self-evidently efficacious, the efficacy of spousal privilege to protect and foster frank communications, in contrast, appears doubtful. Critics have also looked to the ancient origins of spousal communication privilege and disparate gender impact to argue the privilege has outlived its usefulness. Blackstone described the legal principles by which contemporary values can only deem misogynistic that coincided with the creation of the privilege as follows. By marriage, the husband and wife are one person in law. That is, their very being or legal existence of the woman is suspended during marriage, or at least incorporated or consolidated into that of the husband. Well, although the language is slightly misogynistic, the logic works the other way around. So, if you say that they're one person in law, and you look at this from the frame of the wife being merged in the husband, the reverse is true. So, although Blackstone's language could potentially be viewed as misogynistic, the underlying logic is not misogynistic because they're one legal entity and they come into the other. So the frame is a little bit odd, perhaps, but the underlying logic is not misogynistic. They both merge into one legal entity. That's kind of like what marriage is in some respects, right? I mean, that's what divorce is meant to undo the legal entity and divide assets. So when you talk about marriage and the merging of legal entities from one into the other, that's like still true today, and Blackstone's logic is not unbound by that. Despite drastic changes in law and society since Blackstone's day, the spousal communication privilege perpetuates the role of male domination in the marriage because husband usually invokes the privilege to prevent his wife's disclosure of confidential communications, thereby benefiting men more often than women. I don't even know what to begin to say that the privilege protects both spouses equally. And to the extent that men are sharing more things in the marriage, then like they're being more open. And being more open is like something we want to encourage, right? So if men are being more open in marriage than women on the whole, then that seems like a good thing. And we should encourage women to be even more open. So I don't know what to say to that. New feminist scholars, the New Mexico Supreme Court cites feminist scholars, so that's really encouraging. Feminist scholars have vigorously attacked the privilege, suggesting it was created to protect men, who are often reluctant to share their personal thoughts and therefore may need assurance of protection the privilege rules supply, rather than women, who are most likely to decide to confide in others independent of the evidentiary safeguard. Well, if that's true, if the privilege exists to protect men, then your entire logic, New Mexico Supreme Court, undoes itself. Your entire logic was that people would have these confidences even if the privilege doesn't exist. And now you're saying that the privilege was created so men would share more often than they would otherwise. So which is it? Which is it, New Mexico Supreme Court? Would men continue to provide as much information without the privilege, or does the privilege exist because men want to be able to share more in secrecy? You have to pick one or the other. Would men share just as much, or would they not share as much? Pick one or the other, it seems to me. The feminist scholars contend that privacy is frequently used as an excuse to isolate the family from interference by the state, perpetuating traditional gender hierarchies and power imbalances. Lord have mercy in heaven. The rhetoric of privacy, these theories contend, simply ignore the fact that women are all too frequently the victims of a pernicious form of unseen and private violence, and appeals to privacy have rhetorical value in the abstract, but are nothing short of repressive when applied to the actual social circumstances confronting women in our society. I'd again like to note that the privilege exists to words, not actions. So, if the concern here is that men are abusing their wives, women can testify to that all day long because those aren't words. It only protects communications. So, just saying. The feminist scholar says, privacy says that violence against women is immune from sanction and is permitted, acceptable, and part of the basic fabric of American family life. Privacy says that what goes on in a violent relationship should not be the subject of state or community intervention. Privacy states that it's an individual and not a systemic problem. Privacy operates as a mask for inequality, protecting male violence against women. Citing some woman named Linda Seymour isn't a crime, feminist perspectives on spousal immunity and spousal violence. This is the New Mexico Supreme Court, ladies and gentlemen, citing feminist scholars as their rationale for undoing spousal privilege and undoing common law that's existed for I don't even know how long. Let's say 500 years. That seems like a reasonable number. Good times. The traditional justification for spousal communication privilege is premised on assumptions that do not withstand scrutiny. The privacy and humanistic justifications, when closely examined, seem little more than soaring rhetoric and legally irrelevant sentimentality. The misogynistic history of the privilege is obvious and odious. And it appears that the existence of privilege perpetuates gender imbalances and, most critically, may even be partially responsible for the sheltering and including marital violence that disproportionately affects women in entirely unacceptable ways. How? How does it do any of those things? Violence is not words. Words are not violence. Words are communication. If we're talking about violence, we're talking about actions. Actions are not and have never been privileged. Wow, amazing concept. So if the concern here is marital violence and a woman says, I'm being abused, she can testify as to actions all day long, everywhere. It's not a problem. So I don't get this on any level. Words are not violence. It doesn't make sense. Our review of the justifications for and criticisms of privilege leaves us in agreement with Wigmore. The occasional compulsory disclosure in court of even the most intimate marital communications would not, in fact, affect to any perceptible degree the extent to which spouses share confidences. Again, this strikes me as slightly contradictory to what you were saying earlier. What you were saying earlier, quoting these feminist scholars, was that the entire reason for this privilege is that men are reluctant to share things with their wives. And the entire existence for this privilege is to allow men to share things more with their wives. So we create this privilege as an excuse to allow men to share things more with their wives. So you tell me, if you abolish the privilege, will men continue to share as many things with their wives or not? If they will share as many things, then your rationale for why the privilege exists in the first place is wrong. If they won't, then your conclusion here is wrong. So it seems to me one or the other they can't both be right at the same time. It can't be that men will continue to share just as much and they won't. It has to be one or the other. But that's, logic. Now the New Mexico Supreme Court's going to talk about the case that actually got us to this point at hand. So they're talking about this guy, Gutierrez. So let's talk about Gutierrez and how it would or would not apply to him. Gutierrez's decision to talk about murder with his wives was not premised on any legal guarantee of confidentiality. To the contrary, he not only told his wives about the killing, but also bragged about the murder to third parties who were not covered by the privilege. Gutierrez's case also illustrates that abolishment of the privilege is unlikely to chill candor between spouses, one of the putative reasons for recognizing the privilege. Well, I don't know about that because, if we had $1 for every time that a client told something to a lawyer and then also told it to random third parties, we'd also be really, really rich. So, the idea that people, or tell something to a spouse or tell something to a doctor. People have this nasty tendency of not keeping their own secrets, and they have a tendency of telling everyone. So if your rationale is, well, they don't really consider it important because they just would leak it anyway, then we can just undo with pretty much all the privileges. We can undo with lawyer-client privilege. We can undo with priest-penitent privilege. We can undo with doctor-patient privilege because people violate their own secrets all the time. So if it's like, well, they wouldn't keep it secret, so there's no reason to keep this privilege, I guess we can undo with all the privileges. Well, that saved a lot of time, didn't it? Gutierrez told Nicole about the murder not because he required a confidant he knew could not divulge information. He told Nicole about the murder because it seems he surmised that she'd be pleased with what he had done. He threatened her with death if she ever divulged the secret to anyone. Similarly, Evelyn learned of Gutierrez's role in the murder not because Gutierrez perceived her as a person legally obligated to maintain confidence, but because Gutierrez's parents, who knew about the role in the victim's death, spoke openly about the killing only in the most thinly veiled terms and threatened to expose him to criminal consequences of the act. Its clear spousal communication privilege and the principles of privilege were intended to advance played no role whatsoever in the decision to disclose to Nicole and Evelyn the facts that he killed the victim. Well, again, I would think that this logic would hold equally for lawyers because, again, people have a nasty tendency of telling their lawyer something in confidence, and the lawyer says, don't tell it to anyone, and then they repeat to other people. So, if this logic holds that because he would tell third party there shouldn't be privilege, that would apply to all privileges, it seems to me. While the purported benefits of spousal communication privilege are questionable, the resulting loss of evidence is nearly certain. Again, the Gutierrez case amplifies and demonstrates this point. Captain Terrific asks, I thought you didn't have to keep confidence to cover up specific illegal activity either. Sure you do. Well, that's the whole point of privilege. If a client comes to a lawyer and says, I just murdered someone, that is privilege, right? They're coming for that point of expressing that communication. If they come to a priest to say, I just murdered someone, that's privileged in order to seek absolution. So if they come to their wife and say, I just killed someone, that communication's equally privileged. So it's relating a past crime. So it's a privileged statement to the husband, it's a privileged statement to the priest, it's a privileged statement to the lawyer. So, when you're talking about past crimes or past conduct, yeah, that's, if lawyers were, if privilege did not cover past crimes, why would you ever go to a lawyer? Because the whole point of going to a lawyer is be able to say, yeah, I committed the crime, please help me. So it's like, yeah, of course it shields you against specific crimes. Gutierrez used threats and intimidation to silence Nicole, and when Nicole finally agreed to testify, 13 years after she divorced him, he invoked the spousal privilege to suppress the truth. Evelyn described the fighting that typified her relationship with Gutierrez and testified that she had not spoken to him in a year. Permitting Gutierrez to use spousal privilege to block testimony of Nicole and Evelyn would have deprived the court of probative evidence without advancing spousal communication or marital harm in any way. How on earth do you know that? How on earth do you know that? How on earth do you know what would have happened in the counterfactual world? How on earth do you know what he would or would not have said to his wife in the case of the privilege because he spilled his guts to random third parties? I mean, I don't quite buy that. In Gutierrez's case, application of spousal privilege would only subvert fair administration of justice. Conclusion: prospective abolition. This court has a constitutional duty to ensure the pursuit of truth is not undermined by a procedural rule that has outlived its justification. Having carefully examined spousal communication privilege, we cannot accept that it meaningfully encourages marital confidence, promotes marital harmony, or produces any substantial public benefit that justifies its continued recognition. Rather, we believe privilege is a vestige of a vastly different society than one we live in today and has been retained by New Mexico simply through inertia. We cannot escape the reality that the law on occasion adheres to doctrinal concepts long after reasons which gave birth to them have disappeared and after experience suggests the need for change. We conclude spousal privilege is such a concept. Accordingly, we prospectively abolish it and we withdraw Rule 11505, effective for all cases filed on or after the date of this opinion being filed. Because abolition is prospective, we must nonetheless assess its applicability in the current case. And then they go on to analogize its applicability to the current case, but really, we don't really care, because whether or not it's applicable in this current case is not really the issue that we're here for. We're really here for just the fundamental idea of we don't need this anymore, and so as of this date, it is no longer a thing that exists. It is abolished for all cases filed after this date. End of analysis. Privilege doesn't exist, so go on and communicate with your wives just as much as you would have before, or not, depending on which part of the opinion you believe in terms of the psychology as to whether or not people will communicate with their wives or husbands, but for the privilege. And I would point out, incidentally, that this would apply even if you're married in another state. So if you commit a crime in New Mexico and you told your wife about it in Virginia, and then they haul your butt back to New Mexico, guess what? They get to bring in those communications that happened in Virginia because New Mexico doesn't recognize the privilege, even though Virginia does. So this is just super fun, leads to all kinds of issues, and just super good times had by all.